So now we're going to go back in and listen to closing arguments. The prosecution is going to present their presentation first.
Leah Stiff, Ed Smothers, Jaden Phillips, and Mariah Dodds were all injured as a result of the defendant's operation of the motor vehicle. We could bring up the jury instruction on OWI causing serious impairment. And you'll have this written back in the jury room. But the injuries being the result of the operation of a motor vehicle is one of the elements you need to find. That is not in dispute. The defendant was the factual and proximate cause of those victims' injuries. Further, those injuries rose to the level necessary under the law for you to find that element in counts 5 through 9. This is actually stipulated to by the parties. In other words, we agree the degree of injury is not in dispute. Further, you could bring up OWI causing death. The evidence shows that Zayn and Alanah Phillips died as a result of the defendant driving that day. Their death was a factual and proximate result of her operation of the motor vehicle. They do not dispute this. You did not hear from a medical examiner because the parties agree that that was the cause and manner of death. It is not in dispute. The defendant's willful operation of the motor vehicle is not in dispute. The parties agree. We all saw the video of her leave her house and get in her car.
Judge, I agree that there's willful use of an automobile. Tony just said we agree on willful.
No, fair enough.
I guess there was I agree there was an automobile accident. It's a proximate cause of a horrible thing of injuries and deaths.
All right, your objection is sustained.
All right, thank you.
People offer to you that the proofs show that the defendant willfully operated the motor vehicle on the date in question. You all saw the video of her get into her vehicle and drive it away from her home. We think that element is met. Her identity as the driver of the vehicle is not in dispute. People would offer that there are two key elements in this case that are in dispute: the defendant's blood alcohol concentration and her intent when she crashed into the Swan Boat Club. As to the BAC, the blood alcohol concentration, you've heard from several credible, experienced, and dedicated professionals about the level of care and the quality that was taken with defendant's blood draw and the subsequent testing. You heard from Deputy Schmidt, who was able to walk you through the blood draw process and confirm that everything was done according to proper and long practice procedure. You heard from Ro Monday, the phlebotomist, who testified she had conducted thousands of blood draws in her career, and she also told you she followed the correct, proper, and accepted procedures. Former Deputy Krieger, Lab Technician Hopner testified. They both told you that not only were the policies and procedures followed, but they went above and beyond. That typically a blood sample would be dropped in the mail. This one was hand-delivered by deputy to the Michigan State Police Crime Lab. Finally, our two experts in forensic toxicology, Tabitha Faust and Samantha Beecham, testified to the procedure for testing the blood and their results. Their results, that the defendant's blood was a 0.18, more than twice the legal limit for regular OWI and exceeding the limit for high BAC OWI. Further, there was the presence of gabapentin in her blood. But this is disputed. So what can you folks do? What other evidence can you look at to support the experts' evidence of the blood draw? First, you can look at the testimony from the first day of Ms. Sigler and Mr. Wickland. Ms. Sigler testified that she smelled alcohol on the defendant immediately after the crash. Mr. Wickland flat out called her drunk when he helped pull her out from behind the wheel of the car. He further testified he smelled alcohol on her as well. Deputy Karina said she smelled of alcohol, and Deputy Schmidt went through the field sobriety testing with you. In his opinion, she failed field sobriety testing. How else do we know the blood alcohol result was accurate? We know because she told us. We could bring up the first clip from Deputy Karina.
Two 10, 0 being like you're stone cold sober, you can drive perfectly. 10 being you're passed out drunk. Where do you think you're at right now?
7.
A 7? Okay.
What else supports it? When they tested her blood, they found gabapentin in her blood. What did she tell us about her gabapentin?
Run through the medications that you told me about again.
Gabapentin.
When did you take your medications today?
8 o'clock.
8 a.m.?
Yeah.
Oh.
And how do we know she had more than the one drink at Vernus? It's well established in the evidence, and I don't think either side disputes. She left Vernus at the latest at 12:15. The crash was at 3:01. But remember what she told Sergeant Bomia.
Hello, today?
A little bit, yes.
When was the last time you had something to drink?
Probably half hour ago.
Half hour? What did you drink?
Wine.
And just today, you heard from the clerk at Fermi 3, and you saw the video from inside the defendant's house. It's true that she had one glass of wine at Vernus. That doesn't speak to the rest of the day. All of those other pieces of evidence that I've just talked about, just showed you, work together to show beyond a reasonable doubt that the drink at Vernus wasn't her first or her last drink of the day. It's similar to the mystery story I mentioned to you in voir dire, that all of the evidence lines up to show one result, except one thing. And that one thing is defense's expert. But everything else works.
Ken Laurain there. Wow, he's laying it out very succinctly.
He really is, and bringing in the elements and the evidence. I really like that when they're able to weave it in and show the jury. Let's get to a break.
Let's do it. We'll get you back into the courtroom, pick up the state's closing argument against Marshella Chidester when we return.
Race was in the undercurrent of this case from the beginning.
They saw this as a chance to really put the system on trial.
This stuff about playing a race card is preposterous.
The race factor was huge.
This is right after Rodney King.
The racial division was so great that people saw the facts differently.
Trial and Error. Why did O.J. win? A Court TV original series. New episode Sunday night, 8 Eastern and Pacific. Only on Court TV.
Day.
Welcome back to Court TV Live. We are bringing you closing arguments in the birthday party murder trial for Marshella Chidester. It's happening in Michigan, where she's charged with 2 counts of second-degree murder and 2 counts of operating while impaired by liquor, causing death. We saw a video of her where the prosecution says she had lots of liquor that day.
Yeah. Drinking at the restaurant, drinking before and after, according to the video of her own home surveillance camera, caught her with wine in her hand. Her defense says you can't trust the .18 reading, and she only had 1 glass the entire day. Let's see if that flies. Prosecution presenting its close. Let's pick it up where we left off.
That the BAC result is accurate and in line with what she did that day. The second element that people believe are in dispute is the defendant's intent. We bring up the second-degree murder instruction. For the OWI causing death and the OWI causing serious impairment, you only have to find willful operation of the vehicle and that her blood alcohol exceeded the legal limit, or that she was intoxicated, or that she was impaired by alcohol and gabapentin. For the people's first 2 counts, the 2 counts of murder in the second degree, you have to find a separate intent. You can find one of 3 kinds of intent to find the defendant guilty of second-degree murder. You can find that she intended to kill. You can find that she intended to do great bodily harm. Or you can find she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. As we talked about in the opening statements, you can look at what she said, you can look at what she did, and all the evidence and circumstances surrounding this case that you've heard over the last 3.5 days to decide what her intent was. You can think about her driving toward the boat club, straight as an arrow, right between those 2 telephone poles. You can think about what she said to Kristen Sigler right after the crash. Where's Don? She wanted to know where her husband was. You can think about her crashing into the neighbor's truck. And then continuing on her way. At the moment she crashed into that truck, she had to know things were not right. But she continued on. She continued on at full speed and drove her car into a 3-year-old's birthday party, into a building, a route that she knew very, very well. Ladies and gentlemen, this is not a typical drunk driving crash. Not at all. She didn't cross the center line and strike oncoming traffic. She didn't misjudge a red light and rear end someone. At almost 45 miles an hour, she drove through the wall of a building that she had been to countless times. That's what makes this worse than OWI causing death alone. She drove her car into an occupied building knowing she was unfit to operate a vehicle. And if she didn't know she was unfit to drive when she got behind the wheel, she knew it after she hit her neighbor's truck. Restart it. Five, 4, 3, 2, 1. 44.3 miles an hour on a dusty, pitted dirt road. Look at all those things to determine her intent. As most criminal trials are, the focus of this trial has mostly been on the defendant. How she drove, the contents of her blood, and her state of mind. But let's not forget, a trial is about a fair trial for the defendant and for the victims. The ones you heard testify and the ones you couldn't hear testify. It's about an 8-year-old big sister and her little brother. 2 little kids that had just sat down to eat their hot dog and a cake pop at a birthday party. Sat down to have some lunch without a care in the world. They didn't have a chance. It's about justice for these 2 kids. Thank you.
Thank you. Mr. Lopez.
Thank you, Your Honor.